Thank you so much for joining the Surrey Board of Trade. I am Margot Gawley, Client Services Manager of Health and Technology District and Startup Surrey. I want to welcome you to this morning's Digital Impact Learning Lab, Mental Health and Human Rights in the Workplace. I wanted to remind you that if you have any questions during this session, please put your questions or comments in the chat function and we will get to them as soon as we can. If we are unable to answer your questions, we will get back to you after the session is over. I acknowledge that we are in the treaty territory of the Tsawwassen First Nations and the unceded territory of the Coast Salish people, specifically the Kwantlen, Katzie, and Semyamu First Nations. As well, I acknowledge the Inuit and Métis Nations peoples who live and work on these territories. The Surrey Board of Trade is Surrey City Building Business Organization, where they support business and bring business into the city. They are here to advocate for you, to instigate change at different levels of government. Sorry, my little notes. And to be the concierge of connections. Check their diversity portfolio at businessinsurrey.com. As the Startup Surrey spokesperson here today, I do have a few words to say about Startup Surrey. Startup Surrey is a volunteer network of innovative business partners and entrepreneurs, passionate to collaborate and inspire innovation. Please reach out to our website at startupsurrey.org to learn more about becoming a member or to learn more about our partners and connect to resources that support startup businesses. Thanks to Surrey Board of Trade and other founding partners. I hope you all enjoy the Impact Learning Lab Mental Health and Human Rights in the Workplace event today, and let's continue to inspire our growing entrepreneurial community in Surrey. It is my pleasure now to introduce your facilitators from LK Law. Chris Martin, Partner and Practice Group Leader, Employment and Labor, and Tamara Dewar, Partner, Employment and Labor. Chris, over to you.
Well, thank you to the Surrey Trade and Margot for having us today and for all of you joining us in this new normal virtual meetings. We're all hoping that we can all interact more in the traditional sense as things move along this year. But for today, as Margot said, I am Chris Martin. Unfortunately, I'm not the singer of Coldplay, the legendary rock band. I'm just a lowly partner at Lindsay Kenny, which is a law firm. We have offices in Langley and Surrey. We're a full service law firm that assists businesses with their corporate structures and their internal matters, including employment law. We have a wide range of interests with individuals, including family and marital issues, estate issues, and individuals who find themselves in conflict. We have a stable of litigators that go to court and adjudicate disputes when the parties can't agree. I've been doing this for 20 years and I am a litigator, but have a focus on employment law and sometimes knowing how these things end up in court is assisting at the front end and how businesses can build their structure and manage their workforce. I have with me Tamara Dewar, who's also a partner. She's a litigator here in Langley, and she's got an interest in workplace matters, including investigating workplace disputes and assisting businesses with that. She's been practicing law for over 15 years, and she's including practicing in the United States. She is going to start this off, and I'm going to hand it over to her. But as Margot recommended, there will be questions. Just please put them in the chat function, and we're going to deal with the questions hopefully at the end of the short presentation here, and we'll try to make it as concise as possible. And as the handout for today set out, mental health and COVID-19 and the challenges that we all face because of the stresses of the workplace, because of the parameters of the virus, have been a live issue for Tamara and I. We've fielded lots of inquiries, and we hope this gives you some basis or for some structure for your organization. So with that, Tamara, handing it over to you to start us off.
Thank you, Chris. Morning, everyone. You've probably been reading in the news a lot, some of the mental health issues that we're seeing from employees and workers, and that's a concern. So we want to walk you through practical tips today on what can happen if you are facing these issues, how to alleviate mental health stress in the workplace, and how to deal with an issue that comes up, and whether there's human rights matters, accommodation, what type of disability that would relate to, and even the vaccine mandates that are coming out. Now, what we're looking at right now is the mental health has actually decreased significantly with employees because of COVID. And we're seeing more issues arising now. There was certainly a lot of mental health issues at the beginning of the pandemic, but there's even more now that are coming up in the employment context because I think it's been going on for so long that people are just exhausted with it. So there's a combination of factors. So what we're going to look through today is what's going on with COVID and its effect on mental health and employee expectations. A lot of employees have certain expectations about their ability to continue working, what to do if they do have a COVID-19 outbreak, and privacy rights and human rights issues. So that's a lot of expectations, and there's a lot of information out there on the internet, but not all of it is accurate sometimes. So as an employer, you have to be very cognizant of these issues and handle them appropriately, or else we're going to end up in court. And that's what we're trying to avoid today. We want to maintain a healthy workplace mentally and physically, which is you're required to, but we also want to make sure that we're complying with the law. So one of the issues that might be coming up with mental health is the Human Rights Code. And that includes disability, sex, race, language, political issues, and things like that. So we have to make sure that your workplace is compliant. And then with mental health issues, is there a duty to accommodate? Now, the duty to accommodate has a specific goal, and that is to ensure that an employee who is able to work can do so without causing the employer any undue hardship. Now, as an employer, you have to make a high burden to reach the undue hardship if you're alleging that the mental health of the employee is difficult for you to deal with in the workplace. So let's take a look at this slide. This is the mental health of employees during the pandemic. We put a lot of research into this, just seeing what are the main issues that are going to be coming up in the workplace and with employers. So there has been a well-documented increase in the mental health issues. And compiling some of the studies that we've looked at, here are the top 5 issues that are facing employees and employers in mental health issues in the workplace right now. So one is referred to in the legal world as job insecurity, and that covers a kind of a broad spectrum of issues. So job loss, we've seen a number of people lose their job during the COVID pandemic. We've seen a lot of businesses suffer through financial hardship and close, which has resulted in either job loss or reduction in hours and pay and benefits, business closures, and related financial stress. Safety is the second one, and that's fairly self-explanatory. I mean, where there's a lot of concern about catching COVID-19 and then the long-term effects. The third is family health, whether you're dealing with elderly parents or young children, there is a concern about the impact of COVID-19. And childcare. This has been a major issue for a lot of employees, men and women in the workforce, with the school closures, with daycare closures, with isolation. Things of that nature can take a very hardship and a difficult toll on employees who are trying to work during this period, but are faced with childcare obligations because there's simply no one to take care of them. And then the disruption to personal life. And this is a key issue. And a lot of people don't really, I get glossed over sometimes, but you know, there's the recognition that a lot of the stress releases that were normally there for people, whether it's going to the gym, working out with your friends, going to restaurants, movies, and things, which are slowly opening up, and restricted travel, has been in place for a long time, and it's caused kind of a cumulative effect on the mental health of employees. So these are the top issues, top 5 issues that employees have raised about mental health and COVID-19. We'll switch to the next slide. Now, what we're seeing is also an increase in the mental health issues and related human rights matters that are coming up with the gradual return to work after the one phase that we had, and we're coming into another phase, the restart, the reopening phase. The mental health issues are increasing because of the gradual return to work, but also in particular industries that we should make note of, because this will impact some of the legal issues that come up when you're dealing with a COVID-19 claim. So the World Health Organization did a report, and it's called Preventing and Mitigating COVID-19 at Work. It again stressed what we all know is that any job profession that has close contact or physical contact with the other party is going to be a high risk. It goes without saying that healthcare workers is a job profession that has the highest stress and highest risk occupation due to the nature of their work. But there are other high-risk employees that we should make note of. So that would include retail and food workers, production workers, restaurant, hospitality. You're also going to include transportation and public safety worker, construction, social services occupations. It also includes what we don't always think about as social workers, counselors, other people in the healthcare industries that come in close contact. And then the two other final factors that the World Health Organization looks at is increase in COVID-19 and concomitant mental health issues in shared work accommodations, because there's a greater risk of exposure to COVID-19, and then offices with an inadequate ventilation. So let's take a look at some of the practical aspects you want to consider when you're dealing with COVID-19. And what are the employer's obligations? So I think it's important to note right now that it's not just a mental health issue for the employee, but it also impacts the employer. But both parties have obligations when it comes to mental health to cooperate in setting up plans and programs to assist individuals with mental health. And the employee also has to raise the issue and bring it up with the employer, but the employer also has a duty to investigate and see if there are mental health conditions that are impacting their workers. They also have to consider that COVID-19 is a physical risk to workers. And is there exposure for our employer if other employees contact COVID-19 because of one exposed employee, or clients contact COVID-19 because of a lapse in safety planning. So these are exposures that employers need to think about all the time, particularly during COVID-19. So let's take a look at what is going on right now in the legislature, the acts and regulations that we have, and then just common law, which is in the courts. So right now, COVID-19 has been considered a workplace hazard under the Labor Code of Canada. Similarly, Occupational Health and Safety Act and related regulations set forth your legal obligations as an employer to ensure that that you are protected against COVID-19 exposures and that the safety requirements are met by all workplaces. Again, OSHA is enforced by and WorkSafe BC. And I do encourage you actually to go to the WorkSafe BC website in relation to COVID, because they do have some samples and some policies that have been really helpful that look at specific issues that arise. So take a look at that if you ever need to delve into it a little bit more. But one thing we do need to focus on is that the Occupational Health and Safety Act does require that you protect your workers from work-related risks to their health, safety, and well-being. And COVID-19 is considered such a risk. So you have to ensure that there's a physically safe workplace, and that you have a safety plan for your employees, that they can also report to you about COVID-19 issues or report to you about mental health issues that they're facing. And at the bottom of this slide, it says another significant concern is job insecurity, which I talked about a little while ago. Loss of income is a huge financial risk factor for many employers out there. So under OSHA, however, if a worker contracts COVID-19 as a direct result of their employment, they are entitled to compensation if they want to pursue that, if the following conditions are met. One, there is evidence that the worker has contracted COVID-19, and that can be supported either through a medical diagnosis or non-medical factual evidence from the physician. And then the nature of the worker's employment creates a risk of contracting the disease, which is greater than the ordinary exposure of risk of the public at large. Again, this would be workplace areas and workplace conditions that are considered high risk. So I talked about some of the employer obligations and what are employee expectations right now. And why we bring this up is that there's a lot of information out there where employers are saying, oh, I don't have to get a vaccine mandate. Oh, I don't have to disclose my COVID-19 diagnosis. Oh, you know, I don't have to disclose whether I've been in contact with anyone with COVID-19. And they have a lot of expectations concerning two things: their privacy and their rights at the workplace. And employees do have rights, but it has to be balanced against some of the obligations of the employer and the employee. So the employee expectations, what about disclosure of personal information? If you are an employer, you need to know that this is covered under what's known as the Personal Information and Protection Act. We call it PIPA. PIPA prohibits collection, use, and disclosure of personal information of their employees without consent. Now, this is where it's important that you have a well-drafted employment contract, because frequently we include a PIPA disclosure requirement and consent in our employment contracts. And this is going to be very useful because PIPA has confirmed that it does not require consent to collect, use, or disclose employee information for the purposes of establishing, managing, or terminating the employment, so long as the employee was notified that their personal information would be used for these purposes. So again, I emphasize that you can collect some of this information, but make sure that it is confidential. It's the information is stored on a need-to-know basis, and it's not disclosed, and there's no risk of private information, particularly someone's medical information or mental health status, being disclosed without their consent. We'll move to the next slide. What's the other aspect that you have to think about? Well, there's personal information and disclosure. And the second act that's really going to come into play when you're dealing with mental health here is the Human Rights Code. The Human Rights Code of British Columbia prohibits discrimination on what's called personal characteristics. And you probably know the basics. You know, you've got age discrimination, sex discrimination, ancestry, color, criminal conviction, and also mental disability. Mental disability, though, is going to be a tricky one under Human Rights Code. And the Human Rights Commissioner has been submitting a lot of policies giving some clarification on what and what is not a mental disability and what is not acceptable during a pandemic for employers to do without impinging on the human rights of their employees. So mental disability, it's not specifically defined. We're just going to go back to the last slide. See that? Yeah, mental disability is not specifically defined in the BEC Human Rights Code, so we have to look at that in case law. However, the mental disability is not on its own in regards to the age, family status, and gender. The Supreme Court of Canada had said all these factors must be treated equally and given the same benefits and treatments. So the court ruled that all groups protected in the human rights legislation must receive equal treatment. And just to give you a practical aspect to that, in this case, the court found that the insurance company's policy providing long-term disability benefits to those over age 65 for those with physical disabilities, but only 2 years for those with mental disabilities, was discrimination. So there has to be a fairness element in the Human Rights Code when you're dealing with mental health. We'll move to the next slide. And here are some of the factors that are going to be construed as a mental disability or that can affect someone's ability to do their work. Developmental disability, of course, that's going to be a key one. Learning disorders, mental illness, and generally there will be evidence supporting that. Depression, post-traumatic stress disorder, bipolar, alcohol and substance abuse. This is a unique one. It does constitute mental disability in human rights and employment issues. And then here's the key: some anxiety or stress orders, but not all. So each case is going to be fact specific. You will or may encounter an employee that has claims of stress or anxiety during COVID and wants to claim mental disability, but not all stress and anxiety will constitute a mental disability. Again, it's going to be fact specific, but it has to be more than what we call a short-term incident, or more than what is normal and daily stressors in someone's life. But with COVID-19 just being it is a new pandemic, we do have to watch the court decisions, human rights decisions in this regard to see if they broaden the anxiety and stress scope, which is not happening quite now. So, but know that employees may raise this as an issue. So when does a mental issue constitute a mental disability within the terms of the human right law? If these three following conditions are met: the mental condition prevents the employee from performing significant functions that can be performed by others. Second, the mental condition is ongoing. So we're not looking at a temporary, I was, stressed because of a loss of a family member. A couple of weeks later, that's not what we're looking at. For stress and anxiety, mental disability to constitute a mental disability in the Human Rights Code, it has to be an ongoing issue. And then finally, the mental condition is beyond the employee's control. I just want to take you to the last slide in my presentation right now in regards to the mental health. There's a lot of news on mental health right now because it is a major issue that the courts are now dealing with, and the Human Rights Code and the Commissioner are dealing with because of COVID-19. Now, the Office of the Human Rights Commissioner did issue a couple of policies, one in particular in July, to clarify their stance a little bit. And I want to just note this for you because this is important if someone does come up with a claim that there's discrimination against their human rights in relation to employer-mandated requirements for COVID-19. And I'll just emphasize that there has to be a balance between human rights and urgent public health priorities, but frankly, the courts are siding with safety rights take priority over personal rights during this pandemic. There's still a balance, but that's the way they're leaning. So the Human Rights Commissioner and the Human Rights Tribunal have received a significant amount of claims in regards to mask mandates, COVID-19 policies in the workplace. So here's what they issued recently. No one's safety should be put at risk because of others' personal choices not to receive the vaccine. Just importantly, no one should experience harassment or unjustifiable discrimination when there are effective alternatives to vaccine status policies. Ultimately, it is the position of the BC Human Rights Commissioner that the duty bearers can, in some certain circumstances, implement a vaccine status policy, such as proof of vaccination requirement, but only if other less intrusive means of preventing COVID-19 transmission are inadequate for the setting, and if due consideration is given to the human rights of everyone involved. So, takeaway from all of this is that there is a leaning more towards protection of the workers versus the personal choice of the workers. And there's also the requirement under the Occupational Health and Safety Act that you ensure a workplace. Some of the issues that will come up will be privacy and human rights concern. And Chris is going to talk to you a little bit more about the human rights issues that might arise, duty to accommodate some of the requirements for the employees. But mental health is probably one of the biggest issues we're seeing in employment right now. So I'm going to pass it over to Chris. He's going to talk to you a little bit about what are the requirements and some of the legal aspects that we have to consider when we're looking at mental health. So off to you, Chris. Thank you.
All right, thank you, Tamara. I just want to start with this notion of rights and human rights. I think it kind of gets conflated by people, and especially in these COVID times, because human rights means different things to different people. To some, it's the idea that everyone has basic rights. And the issue of right to do something or not do something has been the constant commentary during the pandemic, just because of the systematic restrictions that have had to occur to control the virus. And they have affected our daily lives, as Tamara has alluded to. And the debate from governments and the debate in the public and the debate with your employees would be whether you have the right to restrict them in how they would like to proceed or how they would like to conduct themselves at work. But there has to be there's a distinction in the workplace concerning human rights under the Human Rights Code, under the legislation. It's a shield. It's not a sword. It's a protection aspect in that it means that we're protecting that a scope of an individual's right to participate in daily living and work should not be precluded by their identified protected grounds, being whether it's mental illness or, as Tamara set out, the race, sex, political affiliation. So it really is something that to distinguish it more clearly, it is, for instance, in this vaccine issues that are arising, the Human Rights Code doesn't assert a right to not be vaccinated. It would only be then engaged if there was a medical exemption that precluded somebody from getting a vaccine, and that would be their medical protected ground. I have medical grounds for why I can't do something. So it isn't, as I've said, a sword to assert rights from an employee perspective, or for that matter, an employer perspective, but it's key just to ensure that everyone has, regardless of their personal characteristic, a right to work, a right to access meetings, a right to join unions, a right to be in publications. That's something to recognize, in that that's what workplaces want to ensure, is to ensure that all their staff, regardless of how their own personal circumstances, have access to their workplace, have access to opportunity. And then before tackling the issue of mental illness, it is good to look at, and Tamara has given you some background on the legal framework. But if we go to the next slide, well, we can go through this mental illness. Tamara's gone through that. It's clearly a recognized right under the code. And it's also something that in our daily lives, it's been destigmatized in, quite frankly, in the last 5 years, is that mental health, it can be so disabling as breaking a leg or any other physical ailment that anybody deals with. But to go on to the next slide, Sita, this is where a complaint, if an employer fell in to practice that an employee thought was discriminatory, they would have to establish the 3 elements that are on your screen. One is the protected characteristic, and we talk about your medical health and your mental illness, and how would an employee, how do you know an employee is mentally ill or struggling in the workplace? Well, that usually is medical evidence. There is something that the employee provides you from their doctor or the practitioner that establishes that they're suffering the illness while dealing with the workplace issue. And that's generally how these matters are proved. And then the negative, there has to be negative treatment. There has to be something that has affected the employee to bring them to the ability to advance a claim. And those are pretty common in the workplace. Just think of a termination. Somebody's absent from work or irregular in their workplace, is not living up to the standards, missing deadlines, missing work, coming in late. If they can show that as a result of the first characteristic, their mental illness was the cause of this, then the negative treatment is established. And then the protected characteristic has to be part of the negative treatment. And I'm going to move on to this because sometimes employers say, well, look, I didn't know that this employee was suffering from illness. She was late, he was late, he couldn't complete the task, his performance got so bad that's why I terminated them. Well, there's a duty to inquire that we will discuss later. But so the three avenues are the protected characteristic, the treatment, demotion, termination, and that the negative treatment was caused or linked to the protected characteristic, in this case, mental illness. But once discrimination is established, there is not an unrealistic demand on employers to employ people who, because of illness, cannot discharge employment duties. However, there's an expectation that employers will make reasonable efforts to assist the employee in the workplace. It's not good enough to say, okay, well, you have a mental illness, you can't, your job performance is suffering, but then not taking that into account, that there is a reason why the performance is not satisfactory, and the employer has to take steps to one, accommodate the illness and get reasonable work from the employee. And then if the employer takes those steps, they may justify the discrimination by establishing that the discrimination is based on a bona fide occupational requirement, in that having taken the hardship states or the accommodation to deal with the employee and their illness, that the employee still will not be able to discharge their duties. And as Tamara alluded to, that's a very difficult thing for employers to establish. It can be established. It just has to be systematically done, working with the employee and the employer's obligation. So how would an employer establish a bona fide occupational requirement? Well, first of all, the standard has to be rationally connected to the performance of the job. For example, let's talk about mental illness and COVID-19 and employees working from home. If in the course of working from home lately, and the employee notifies you that she's or he is suffering from a mental illness, and then all of a sudden you said, okay, well, now we're going to demand that you have to be in the workplace when they've been working and being accommodated and doing as much as they can from home. That would be something that is a standard that would be contested, in that there's been past practice of this employee working from home. And that goes to number two, is it honest and in good faith? Conversely, instead of demanding the employee to come into the office in these difficult times, was the employer said, okay, well, look, let's ensure that you have time to deal with your illness, or let's reduce your workload even while you're working at home. That would be a more rational way to approach something. And then, the third element is the standard reasonably necessary to the accomplishment of legitimate work-related purpose. And the work-related purpose is really the employee's performance and their expectations of them. But the employer has the duty to show that the new standard or the new accommodation was reasonably necessary, and it must be demonstrated that there were no really other alternatives without the employer suffering, in that they weren't getting value for paying the employee, or that it would create a work environment that was untenable in the workplace. We go to the next slide. But there, as I stated, it's a high bar, but an employer can establish that it is undue, or there's too much at risk or too expensive for them to accommodate the employee. And that means the employer has to show hardship. including financial costs relative to employer size. It's a matter of taking into account, well, you know, if you're paying somebody $40,000 a year and you have a $10 million business and you're only getting 75% of this employee, is that expense undue? I would think anybody who adjudicated the matter would say no. There's also issues in unions where you disrupt a collective agreement. You have to move in those circumstances, even in a non-unionized workplace, you're moving an employee around in such a way that it's untenable for other employees to work collaboratively or have their rights infringed upon the accommodation. If there's morale of the employees, now that would have to be a very demonstrably, look, I'm going to lose 10 employees if I continue on in this practice. And then there's issues about interchangeability of the workforce. You know, there's certain jobs where you can't accommodate. You're a pilot flying helicopters, or there's a certain professional or standard that it's a limited skill employee or a highly skilled employee in a limited situation. The adaptability of your facilities, if you can accommodate the individual in your workplace. And then, of course, there's safety concerns. One of those would be, for instance, an example would be years ago, the requirement on hard hats in the workplace. And there's religious, for example, turbans, that there's a religious element to that. And there has to be an accommodation. You can't simply say because you can't wear a hard hat, you can't, which is a valid safety concern in some of these industrial shops. You can't have a job here. There's other ways to deal with those matters, and they've been adjudicated. If we go to the final slide, this is really where, if you're acting for an employer or working in an organization, these are the things that you want to look at when you're dealing with any human rights issue, but especially mental illness. And that is, well, the first one is do not discriminate. Well, that's common, but it's also creating a safe workplace where people don't fall ill or fall into the stresses that could cause them being disabled. And that deals with recognizing stresses in your demands of employees and ways to mitigate that at the front end so you don't have these issues arising. There's also issues of, you know, when you're seeing an employee struggle, you need to go in and talk with the employee, but you want to limit yourself to that because you don't want to become their health practitioner. You don't want to become their confidant. That isn't something that you're skilled at or will be fruitful in dealing with the issue, and that you want to provide the support for, especially with mental illness, for the employee to get the required help they need. If we look at 2 is creating a mentally healthy workplace culture, that goes to the destigmatization of mental health. That's probably common in most workplaces, you know, recognizing that, one, we're under stress or there are stresses in the workplace, and how can we help, and letting the employees know that there are avenues for them to talk to human resources, or many employers have third-party counselors, or just making the issue real and not closeting it, as they say. That's something that proactive employers do. And then how you could do that is by having policies and procedures, and including signs of mental illness, and showing them how that if there is struggles, how can we assist and train. Those are things that, or what avenues, as I've talked about, they can access to deal with the issue. The third element is being aware of mental illness and signs of mental illness. And I've alluded to these things already, but there are some signs that are pretty consistent. I've seen them in my workplace. I've dealt with employers who see them, and it starts with, the basics: late arrivals, frequent absences, lack of cooperation, and otherwise engaged employee all of a sudden becomes uncooperative and disruptive. The obvious signs are decreased productivity, accidents or safety issues. I see difficulty concentrating or remembering things. That's one where you feel like you're engaged with the employee, and then all of a sudden 3 days later you're having the same conversation. There's more to that than just normal loss of circumstance. So, and then of course with some mental illnesses, there's the flow of engaged and active and proactive one day, and the next day very disengaged, negative, and the like. And those are some of the signs that you can see. And a good organization has human resources managers, and even the principals are aware of, well, look, what should I be looking? And once you see signs of mental illness, that's the time to be proactive and encourage, going back to step 2, these employees to access anything that they need, or encourage them to sit down and ask what's going on in the workplace for them and how you can assist. But if it comes to you that, look, this person says, look, I've got stresses outside the home, I've got ill children, ill family, I'm worried about, in this instance, contracting COVID-19, I'm not happy with our working arrangements, I feel like I'm too close to people, I'm concerned about the virus, and this is causing such stress on me, then you can request medical information. And medical information is not, it is one of these rights that everybody thinks, well, this is my medical information and I'm entitled to it, you're not, as the employer. Well, that's simply not the case when you have performance or attendance issues with an employee, and they're based on your inquiry and your signs that you gather that there's a mental illness going on. You can request medical information, and the employee has the obligation to provide it. In that, when we go back to how I talked about how these claims first arise, or how they could proceed in the courts, the employee has to establish that they in fact were suffering from a mental illness that was affecting their daily living and job performance. So you're entitled to ask for it, and they should provide it. And the way I say to employers is, you just don't you get a medical note. If it's not satisfactory, you can follow up and give the employee a note to take to their doctor that, they don't have to specify the certain condition or all of the mechanics of the medical condition, but they need a doctor to certify that, yes, it's being treated. And then you can say, okay, well, when can you be back in the workplace? Or this is the job duties of the employee, how can we accommodate them in the workplace, and press for information that assists not only you getting the employee back to work, but gives you some certainty. Okay, well, this is the problem we have. Do I need to get new staff in or temporary staff to cover? So there is an ability to request the medical information. There's an obligation on the employee to provide it. And from there, it's once you've got the medical information and the establishment that there is a problem with the employee, there is an illness that needs to be dealt with, it's key in all of these matters is to keep it confidential within a limited number of decision makers in the organization. The ability to provide the medical information, I've talked about the employee's obligation, but it's also the employer's obligation to keep it confidential and to ensure that others aren't talking about the employee's problems or their medical information is being disclosed to them. And then finally, in accommodating the illness, it really goes back to this very difficult standard of what's reasonable in the circumstances, and being creative in trying to get value for the work and trying to ensure that the employee can still participate in the workplace given the difficulties. And those are really fact specific. It depends on what an employee is doing. In my instance, I have paralegals and lawyers that work with me. If a doctor said, well, what this employee needs is time at home because of the stresses of COVID in the workplace, and despite the employer wanting to bring everybody back, and we may all be opening up in later this month, according to Dr. Henry, it would be a note saying, well, this employee dealing with this mental illness or the stresses of the workplace needs to work from home. And then you can assess that. In my instance, we've been working remotely for 18 months now. That wouldn't be an unreasonable accommodation. Now, would it continue on forever? No, for the circumstances that you're dealing with, and once the employee is well, you can require them to come to the workplace as long as it's in a reasonable expectation. So, in summary, it's really being proactive, and proactive means not only recognizing mental illness, but seeking out employees when they're struggling early, not letting them get to the point of overloaded stress. 2 is then accessing the information that you're entitled to. Once an issue is raised, you're entitled to know how long this employee is going to be off work, or even if they can't be off work, if they have to work at a reduced capacity, you need the medical information on why that is so, and how the doctor thinks that the employee can discharge their duties. If they can't, they need time off, that's fine. If they can, then you need to work reasonably in trying to accommodate that. And failing the reasonableness of that, there could be difficulties if you elected to terminate, demote, change their job duties. Now, saying change their job duties, you could do that within the context of accommodation that is reasonable. Somebody is doing paralegal work, they feel it's too stressful, but could they do legal assistance work and are agreeable to that? And that would be working hand in hand with the employee and trying to come to a resolution. So with that, that's all I have usefully to say within the confines of our time. We've got a few questions, I think. Tamara?
Yeah, thank you so much, Chris. That was really helpful. We do have a couple questions. I'll just start from the beginning. One of the first questions. Ms. Madsen, thank you. Are social workers and counselors considered high-risk occupations due to the nature of their work and because of their interaction, exposure to multiple clients? I think the key is more so they probably have a high-risk occupation with mental challenges, yes. But in relation to the COVID-19, it's more the one-to-one interaction that's happening. The interaction and exposure to multiple clients has put them in a high-risk group. Second question, and I think this was in regards to when I was previously speaking on our slides. How could you confirm that a COVID-19 exposure was in fact the result of the workplace, contracted in the workplace? That's a good question. And that's one of the issues that may arise. I often find that sometimes the evidence that's needed to establish, either a disability or something occurred, can be quite high to reach the threshold. But with COVID-19 and the fact that they're trying to disrupt this pandemic and reduce exposure, I do think if you're going in that regard, when you're trying to get money for workers' compensation, I think they'll just be looking at elements. So when I review that, some of the evidence factors are, do you have a medical diagnosis of COVID itself? That's preliminary. Was there an exposure reported? And you can in the workplace, so whether there was an email or someone attended, if there's confirmation that there was someone else who exposed, if there's been past exposures for COVID-19, and simply just circumstantial. Sometimes there's no way that you would have obtained this exposure had it not been for you coming into the workplace. And so far that I found they haven't been too stringent with that. Only because of the recognition that the pandemic is causing so much harm and it's rather novel, the whole concept of it in the last year and a half. So those are some of the factors that they're going to be looking at.
I have 2 points
Yeah.
on both. I'll start with the first question from Ms. Madsen.
Mhm.
Is I think that high risk occupations are contextual in that, of course, social workers and counselors are one of the requirements is visiting with third parties, people who are in need of their assistance. It really comes down to what limitations you can put in place. We can safely interact even in high risk situations of having to meet people. And so the term high risk, I don't think it's been defined, but it's really, what are you doing at the time? One thing that was obvious at the front end of the COVID-19 exposures was, for instance, food service workers who were processing meat, where they were all working together in a closely confined and unventilated space. And that's where the Workers' Compensation Board really worked on parameters of how work should be done, the distancing, the masking, the disclosure of illness. And I think in a social work counselor situation, that would be the same. Before, depending on what your employer says about having to meet people, it would be, well, the interaction would include masks, disclosure of you're ill, I'm not meeting with you. One that's going to come up is whether you're vaccinated or not. And I see a question down at the below, but about that, and I'll touch upon that there. So the definition of high risk really is fact specific, but given the nature of the virus and the protections that are there and the inquiries that you're able to make, it would be daft for an employer not to specify to its clients whether they're at-risk youth or other at-risk thing is setting up a framework for how their employees interact with their clients. And they would then go to the second place. The second question from Cheryl was whether, how do you confirm that exposure was in fact a result of the workplace? Well, that's difficult in that, but not so difficult. If you think about contact tracing, and you think about attendance issues, you're needing to know who's at your work site. You're giving third parties are entering in, and they're making disclosure of whether they've been sick or ill. So you could trace back to where you were and what time you got that. Now, would it be 100% regarded whether you in fact got it in the workplace? Well, these things are always on the balance of probabilities. If there was 3 people working in your office and they all got ill within the incubation period and the employee was ill as well, I think the presumption would be that workplace created that environment there. Then going to Ms. Cotterell's question about mandatory vaccines, this is where I talk about rights and individual rights versus collective rights, and Tamara talked about safety. Well, your individual right not to get vaccinated, you can make that decision, but you can't then put others at risk. And the science is that an unvaccinated person is a higher risk in closed setting and other just simple exposures to those that are vaccinated. Quite frankly, they're putting themselves more at risk, but I'm not sure. I don't know what politicians or governments do. I know that employers, even small businesses, I think, in my own view, could implement a reasonable vaccination policy on the basis if you give the employees long enough notice that, look, at this date certain, we require it. Now, it depends on what you're doing, in what work you're doing, but that's always the context. And then if an employer refuses, then it's an issue of whether they have a medical exemption or under the Human Rights Code, a religious exemption not to get the vaccine. I can tell you about medical exemptions because my wife works at St. Paul's. They're very slim. It's basically you have to be allergic to the vaccine. so I'm not sure if public health will mandate it. It seems to me that they would be something that they should be looking at. And I do recognize how difficult it is for small business, especially those that are reliant on customers coming in and out of their places, to deal with the vaccination issue, because if you have unvaccinated clients coming in, you're putting your employees at risk, and vice versa. You got unvaccinated employees, you're putting your clients at risk, depending on the circumstance. But I'm of the view that a well-crafted vaccination policy can be mandated, and there could be consequences for employees if they didn't abide by it, subject to their medical or religious exemption. Tamara, do you want to get the last question there, or?
Yeah, of course. Yeah, I understand with this vaccine mandates, it's very tricky. It is a gray area right now, and it is hard on employers. But there's also this overriding obligation to protect not only your employees but and your clients as well. So yes, it would be wonderful if they mandated it for everyone, because that's a lot less burden on the shoulders of employers to enforce these. Which is a good point. I like the last question as well. Volunteers versus employees. Good. Contract and COVID in your workplace. Are these dealt with in the same way? What an interesting question. Kind of, it's a tricky situation too. So, look, if you've got an employee, they've got certain recourse under the Human Rights Act and privacy rights. But remember, when we're dealing with workplace safety, everyone always focuses on employee safety, but you also have to remember that you have some obligation for the protection of your clients. So workplace safety is actually broader than just your employees. So if you do have volunteers coming to the workplace, yes, I do believe that you do have obligations to make sure that they are protected to an extent from workplace hazards, workplace exposures. You certainly could have liability if they were injured as well. Will they have the same recourse if there's any employment issues with them, whether they go to human rights or disclosure of personal information, perhaps? But again, don't just segregate. Oh, there's employees versus volunteers, and volunteers are not going to have the same rights. Always remember that these safety plans, these safety requirements under occupational health and safety and WorkSafe BC also applies to clients and volunteers that are in your organization. So there is a duty that you're going to have to make sure that there's safety precautions in place. And what we should talk upon is in British Columbia, for employers, there are mandated safety plans. So you must have a safety plan in place. So I hope that kind of answers that question in regards to volunteers. They do have
There's a couple more, Tamara.
Yep, go ahead.
Tara Sudbury has asked about, in a large organization, is there an obligation by the employer to reassign the person to another division or department? Are they obligated to train the individual for this move? That would be a reasonable accommodation, especially in large organizations are the ones where there's so many options to deal with an employee, because there's so many different avenues for an employee to be productive, that I don't think it would be undue to reassign or train.
Yeah.
So the larger the organization, the bigger the duty. So for that, if there is an avenue, another division or department which requires some training, to the extent that the training would be the issue. Is it undue? Is it a 2-year apprentice program, or is it something that an employee could learn in a 2-month, 3-month period, 3 weeks? So I would say that there is an obligation for the employer to at least look at that as an alternative, another division, another department, and further training. Those would be steps in the accommodation process. There's finally, I think we're just at the cusp here, more vaccination policy. Is it reasonable to refuse service if not vaccinated? Well, there's ways around service, and you'll recall at the outset of COVID-19, people couldn't come into offices, people couldn't interact, but we figured out how to, for instance, in our office, how to get checks signed, how to exchange documents. So the refusal of service has to be reasonable. It isn't, if you have a vaccination policy in your workplace that sets up, but if it's an interaction in which, for instance, I know for doctors, for instance, are saying, well, look, I'm not going to meet with you if you're not vaccinated because you have to come into my office. I think that's reasonable to the extent in the circumstances. All these things are fact specific. Any lawyer who guarantees you anything is not worth listening to. So again, it's contextual, but it could be a refusal service is reasonable given the nature of the unvaccinated currently with the Delta variant. And then there's a question of, could an employer be liable if there were side effects from a vaccination? Well, I don't think so. I can't guarantee that. But what you're saying as the employer is, as a condition of employment, we require vaccination. Make a choice. If you don't want to remain employed, then that's your choice. If you want to remain employed and have a vaccination, which is being given the context that the government's encouraging it, the scientists, the medical doctors, everybody who's fighting this pandemic is saying this is a reasonable step. I don't think there's a risk at getting a side effect, but the connection to that would be your own personal choice at the end of the day. I think you could create a claim that, look, I would have never got vaccinated, but for I had to pay my mortgage. The reality of that and the causal connection hasn't been adjudicated, but I think that would be a small risk. I think that's all I usefully can say.
Great, thanks so much, Chris. I know there's a lot of issues coming up with this vaccination policies and mandatory vaccination policies, things of that nature, and we're happy to address some of these things. Remember, the pandemic just came out a short while ago, so we're still dealing with some of the case decisions, human rights tribunals coming out, but we really wanted to address the mental health issues in the workplace because this is something we keep on seeing repeatedly. So thank you so much, everyone, today, and I'll let me finish off, but thank you, Chris.
Thank you, Tamara and Chris, for being with us this morning and sharing your insights. We will be sending you the recording and the facilitator's contact information after this session. Many more of these type of sessions are coming up, so please be sure to check our website at businessandsurrey.com. Make it a great business day, everyone.